Yes, good evening. I can see you, Becky, so we can start off the class as we wait for the others. So today we are going to look at defamation and occupiers liability. So we were looking at law of torts last time. Law of torts. So today we are going to look at occupiers liability. Occupiers liability. And also we'll be able to look at defamation. So I think last time we looked at trespass. We looked at trespass. So today we're going to look at occupiers liability. Then of course look at defamation. So in our previous class, we are actually able to categorize trespass into three as a form of tort. So we said under trespass, so you can have trespass to land. So you can have trespass to persons, and you can have trespass to goods, whereby we say trespass is simply the unauthorized access to a person's either property, or maybe to a person himself, or maybe it could be to goods. So when you talk about occupiers liability now, in this case, occupiers liability as a form of tort is basically talking about the responsibility of an occupier of a property, the responsibility of an occupier of a property, the responsibility of an occupier of property on those who are likely to visit the property. For example, if it is maybe a building, let's say, for example, a supermarket, what are the responsibilities of the occupier with regard to those ones who are likely to visit or come to the premises? So in this case, the term occupier is actually used because the land can actually either be leased, or the property can be leased, or maybe the person who has that particular property or occupying the property could actually be the owner. So in this case, the owner, or maybe the lessor of the property. So the lessor is, for example, someone who has hired the property for a period of time. So maybe if it is that particular supermarket you're talking about, it has hired or basically leased that property or maybe building. So the supermarket becomes the occupier. So it has a particular responsibility over those who are visiting that particular supermarket. In this case, we are talking about, for example, the customers who are likely to come to the supermarket. So what is the responsibility of the occupier of the property with regard to those who are visiting the premises? So that is what we mean by occupier. So he has a responsibility. So he can basically be held responsible in terms of actually ensuring the safety of those who are visiting the premises. So in this case, if you go to a supermarket, in any case, maybe you'll see they are basically indicated. Maybe you walk carefully, maybe the floor is actually slippery. If you are using stairs, maybe they tell you to basically be careful when you're using the stairs, so that you cannot actually basically slip as a customer. So if there are no indications or such indications or signs or signages in the supermarket to clearly indicate or guide the customers, so most probably those customers are likely to sue the supermarkets, or what we call occupiers liability, in case of any injury or danger that actually arises out of being in the supermarket. So the occupier, that is the supermarket owner, basically will be held responsible or liable for all the liabilities that actually occur with regard to those who are visiting the premises. So in a nutshell, or basically in simple terms, that is what we mean by occupiers liability. That is what we mean by occupiers liability. So in short, maybe let me just share. So occupiers liability generally refers to the duty owed by land premise owners to those who come onto their land. So that duty that is basically owed or basically expected of a person who is actually occupying either land or basically a particular premise. So what is expected of these particular persons? What are the expectations? So some of them have been able to mention. So the occupier owes a common duty of care to all his visitors. So he has a duty of care to all the visitors who are coming to that particular supermarket or basically that particular premise. So he has a duty of care to ensure maybe their safety. So the common duty of care is to take such care as is in all circumstances of the case, reasonable to see that the visitor will be reasonably safe for using the premises. Then number 2, visitors are persons who have expressed or implied permission to enter or use the premise or the premise of a person, So those ones who have basically maybe been licensed or actually been allowed under the law. So those are the persons you can actually be able to call as visitors. So maybe it's someone who has been licensed to visit your premises. So he's the visitor. So either it can happen in a situation whereby maybe you've actually been able to invite them. You've actually invited them, or basically we can actually talk about they have come in as a result of a license or been allowed to visit the premises. So those are the persons we are calling visitors. So visitors are persons who have expressed or implied permission to enter or use the premises of a person. So in this case, we're talking about invitees. So those who have been invited to come onto the land and therefore have expressed permission to be there. So they have expressed permission to be on that particular property. Those who have been licensed, so someone has been licensed, for example, an officer from the Kenya Power and Lighting Company has actually been licensed or been allowed to come to your premises, basically to be able to maybe read the meter readings, or maybe someone from a water company, you can be able to visit the premises to basically read the meter in terms of how much you've been able to use in terms of water. So those are basically licensed persons who can be able to access your property. So you have a responsibility over them to maybe ensure their safety. So those entering in exercising a right conferred by law, for example, a person entering to read an electricity meter. So the standard of care varies according to the circumstances. The legislation refers to two particular situations where the standard may actually vary. So an occupier must be prepared for children to be less careful than adults. So most probably in a situation whereby you have children, you expect them to be very maybe less careful while they are using the premises. So you must take maybe the highest or more precautionary measures, especially if those people visiting the premises are actually children, because for them, maybe they need to be guided to ensure they need more guidance to ensure their safety. So the standard of care basically will actually depend on the circumstances surrounding those who are maybe visiting the premises. Maybe it could be adults, or maybe it can actually be children. For the case of children, we are saying basically the standard of care will actually basically be very, very high, because for them, they need a lot of guidance in terms of actually ensuring their safety. So an occupier may expect that a person in excess of his calling will appreciate and guard against any special risks ordinarily incident to it. So the occupier is not liable for the negligence of an independent contractor once he is satisfied that the contractor was actually competent. So the occupier of the premises cannot actually be held responsible for those accidents or maybe failure of safety measures that actually arises out of maybe the negligence of an independent contractor. In this case, for example, if you talk about that particular supermarket, if the supermarket has pillars inside, then it happens that this particular pillar maybe falls on one of the customers. The supermarket cannot actually be held responsible in case it actually hired the services of a qualified independent engineer. So this engineer was actually qualified to build the pillars in the supermarket. So in case of maybe any faulty, the pillar becomes faulty, the person who can be held responsible in this case, it should actually be the independent contractor and not actually this particular occupier or this particular supermarket. So that's why they're saying that in case of services provided by an independent contractor, it may be coming up with that particular building or maybe premise. The occupier might not actually be held responsible, but it'll be that particular independent qualified contractor who will be held personally responsible. Then the common law duty of care does not impose on an occupier any obligation to a visitor who has willingly actually accepted the risk. So sometimes also if you've actually accepted the risk, then you as a visitor or maybe as a person entering the premise, then of course the supermarket won't actually be held responsible. So clearly they have indicated that maybe the floor is maybe slippery, but you still actually enter the premises. So long as they have actually been able to indicate, it simply means that you've actually accepted the risk when you enter the premise. So you cannot hold this particular supermarket responsible. So that is basically what we mean on the circumstances surrounding, for example, the standard of care and maybe who can be held responsible, or when the occupier can actually be held responsible or not responsible or not. So that is in a nutshell what we mean by occupier's liability, that an occupier of a property or an occupier of land, he has a responsibility of ensuring the safety of those who are visiting the premise. So he has a duty of care to ensure those coming to the land or maybe the premise or property are actually very, very safe. So a failure to such or failure to do such, then this particular owner or basically the occupier of that particular property can be held responsible under what we call a tort known as occupier's liability. He has failed on his responsibility with regard to those who are actually visiting his premise or maybe his or her property, his or her property. So we can look at the defenses. So what are the defenses? The defenses under occupier's liability. What are the defenses under occupier's liability? Because the key thing here, as I told you, under the law of tort, you just need to be able to understand the tort itself. After understanding the tort itself, be able to maybe set out or basically explain some of the essential characteristics or basically how this particular tort can actually be explained. Then of course, also understand the defenses an accused party can actually be able to use in case he has actually been accused of such kind of a tort. So in this case, that supermarket we are talking about, for example, if it has actually been accused of occupier's liability, how can it defend itself? How can it defend itself in a court of law? That a customer actually walked in, and of course, while in the process of actually maybe carrying out window shopping, or basically while in the process of actually shopping for his or her goods, he basically slept on the floor and actually fell and he was actually injured. So can that particular customer actually accuse the supermarket of maybe what we are calling occupier's liability? And in case he accuses this particular supermarket of occupier's liability, how can the supermarket actually defend themselves in a court of law? So number one, they can actually be able to plead or basically plead for a defense known as 𝗖𝗜𝗙𝗙𝗠 and 𝗖𝗑𝐵𝗙𝗠. So what this one is basically in Latin, it simply means that this particular customer voluntarily accepted the risk. So what we mean by that, even after the supermarket clearly indicating that the floors in this particular supermarket are actually very slippery, so the signs have been actually put everywhere, still this customer was actually able to walk into the supermarket. So the supermarket won't be held responsible because of this particular principle we are calling the 𝗖𝗜𝗙𝗠 and 𝗖𝗑𝐵𝗙𝗠. This customer voluntarily accepted the risk that the floor in this particular supermarket is actually very slippery, and he still went ahead and actually entered the supermarket to carry out the shopping. So if he accuses this supermarket of this particular tort we are calling occupier's liability, they can't be able to defend themselves by simply being able to state the customer voluntarily accepted the risk. Contributory negligence. So contributory negligence. So damages may be reduced where the visitor fails to take reasonable care for their own safety. So if the visitor actually contributed to part of the injury or damages arising out of the premises of the occupier, then that can be pleaded as a form of defense. Exclusion of liability. So it is where an occupier, it allows an occupier to extend, restrict, exclude, or modify his duty to visitors insofar as is free to do so. So the occupier employed a competent independent contractor. So this is basically what we're talking about. That engineer who built the pillars in the supermarket was a qualified engineer. So they expected, this supermarket expected that this qualified engineer will build very firm pillars. So there's no way they can actually be able to fall on a customer. So in case this one of them actually falls and a customer is actually injured, then the person to be held responsible is not the occupier of that supermarket, but it is that qualified independent contractor who basically built this particular pillar you are talking about in the supermarket. So in the case of basically an injury arising out of the negligence or basically failure of duty of care by an independent contractor, it is the independent contractor who will be held responsible and not actually the occupier of the property, So that is basically what you need to be able to understand about this tort we are calling occupiers liability. What should come to your mind first is basically occupier, someone occupying a property. What are his or her responsibilities with regard to those basically who are coming to visit the premises? So that's what we mean by occupiers liability. So you can look at defamation. So as the last form of torts, defamation. So what is defamation? So it is simply basically talking or giving out information is not actually factual or true about a particular person without any form of authorization from the person. So basically, if today I start talking about an issue or something about Anne, which is not factual about Anne, then Anne can actually basically be able to take me in a court of law and actually accuse me of what we call defamation. So it is normally in two forms. So you can have a defamation categorized as being either libel or number two, sometimes we can have what we call slander. Libel is defamation in permanent form. Libel like this. And then you have slander. Libel is defamation in permanent form, while slander is not actually in permanent form, but just by word of mouth. So when you talk about libel, we simply mean that this particular defamation happened in a way that it came out maybe in a publication or in a printed form. It's like in a permanent form. So that's what we mean by libel. That is what we mean by libel. So you can be able to see there what is defamation. So this constitutes publication of a false statement about a person, which ends up lowering the person's reputation in the estimation of a right-thinking members of the society without justification. So basically publishing or maybe mentioning a statement which is not true about a particular person. So that's what we mean by defamation. So it's a tort that actually constitutes publication of false information or giving out false information about a person. So which lowers his or her reputation in the society. So what are the elements or key characteristics? So number one, the defendant must have made a false statement. So that should actually be very key. The statement that was actually made should actually be false, not factual. Because if it is factual, then that is not actually defamation. So the statement I made about Anne, that statement I made about Anne, it should actually be very false so that she can be able to accuse me of what you are calling defamation. Then the statement must be defamatory, that is arouse some form of ridicule or contempt from the right-thinking members of the society. So it wants to make people to be able to ridicule you or maybe laugh at you. So that element should actually be present. The statement must refer to the plaintiff. So before Anne takes me to a court of law for defamation, Anne should actually clearly be the plaintiff. So it should be the one who has actually been accused. Know that basically it was Anne, the statement was made about Anne, and of course the person who ends up in the court is Elijah. The statement was not about Elijah, it was actually about Anne. So the Anne should actually be the person or the plaintiff who should come before the court. Then the statement must refer to the plaintiff, so that one we've said. Then the statement must be made in public. It should be made in public, either in a publication or maybe just by word of mouth. So if those elements are actually present, then of course, with regard to a particular statement, then one can be accused of what you are calling defamation. So that's what we mean by defamation in a nutshell or in simple terms. But we've said it is actually in two forms. It can either be in a permanent form known as libel, or maybe it can actually be in a non-permanent form just by word of mouth known as slander. So those are the two forms or types of defamation. So what is libel? As I've explained, it is, so they have started with slander, so maybe we can start with slander. So this is a non-permanent form of defamation, usually by word of mouth. this kind of defamation is actionable upon proof of damage. Though there are some exceptions, such as, so you can see what they are saying. If that defamation is not in permanent form, it is just by word of mouth, there must be a form of proof. So you must produce evidence. So maybe a video recording, or maybe something to clearly indicate that someone made that particular statement, because it was just by word of mouth. You know, if it is actually libel, then it is actually actionable without any form of proof, because the proof that will be there, the evidence that will be there, is maybe that printout of a newspaper or a magazine, whereby that statement that was made there is not actually true about a particular person, because it is actually in a permanent form. But you know, by word of mouth, maybe someone mentioned the statement while other people are not actually there. So gathering the evidence or gathering the proof might not actually be very easy. So, or maybe someone can just accuse another person. He said something about him, which is not factual, yet it is not true. So you must actually be able to produce or be able to prove before a court of law before you can accuse someone of what you are calling defamation by slander, defamation by slander. So that's what they're saying. This kind of tort is only actionable. It can only be brought before a court of law in case there is actually some form of proof of damage. So you must actually be able to prove that there was actually damage or an injury caused to the other party or the plaintiff before you can plead before or bring before the court of law an action known as defamation by slander. Although they are saying in exceptional circumstances, there's no need to prove there was actually damage. You can always be able to bring a case before a court of law. For example, in a case where the statement imputes a criminal offense punishable by imprisonment. So if today basically I make a particular statement about Becky, which imputes some criminal activities on Becky, it simply means that Becky doesn't have to wait for the damages to actually occur, or maybe for him to basically be laughed at, or maybe be looked at by other people as a person who's involved in criminal activities. That one, there's no actually need for him to be able to wait for the damages to actually occur. He can simply go ahead and actually accuse me in a court of law of what you are calling defamation and what you are calling slander. So if someone imputes criminal activities, there is no need to prove damages have occurred. What we mean by damages is that out of that statement that was actually made, a loss actually occurred, or maybe your name in the society was actually, maybe your character was actually looked at by people in the society as not actually being correct. So you don't have to wait for such to actually happen. So long as someone has actually been able to impute maybe criminal activities on you without any form of proof, it simply means that you can actually be able to go to the court. Then number two, where the statement imputes contagious disease on the plaintiff. A contagious disease basically maybe it spreads very, very fast. So today someone just accuses Becky, maybe she says that Becky is actually maybe having a particular disease which is actually very contagious, yet it is not true about Becky. So Becky doesn't have to wait for basically the repercussions to happen. Immediately she hears of such, she can actually be able to bring the action in a court of law, and it will be allowed by the court of law to be heard as a case against the defendant. Then number three, where the statement imputes unchastity on women. Then number four, where the statement imputes incompetence on the plaintiff in his trade, occupation, or profession. So if you are qualified, maybe doctor, yet someone out there is spreading rumors that you are not actually a qualified doctor, such that it impacts on your profession, you're not actually able to get maybe patients to be able to treat, or customers. So you don't have to wait for such to happen. So immediately you hear of such, then of course you can actually be able to accuse someone in a court of law, of what you are calling defamation by slander, defamation by slander. Then libel. So this is a permanent form of defamation in the sense that the statement is printed or documented. It is actionable the way it actually appears. There's no need to actually to be able to prove there are damages. So this one, the way it appears, what they mean by per se is just actionable the way it actually appears. So there's no need to actually basically to prove there's actually damage here. But under slander, you have to prove there was damage caused to the plaintiff before the action can be heard or be brought before the court of law. So what are the differences between the two, or what have you actually been able to note as the difference between the two? So number one, libel is defamation in a permanent form, whereas slander is defamation in transient or non-permanent form. Libel is not merely actionable as a tort, but it is also a criminal offense, whereas slander is a civil wrong only. Then all cases of libel are actionable the way they appear, but slander is only actionable on proof of actual damage with 4 exceptions. So the 4 exceptions, so under slander, you have to prove there was damage. Under libel, you don't have to prove there was actually damage, because this one is actually in a permanent form. It will remain in that particular newspaper that can be read for even over 100 years or maybe over 50 years. People will actually be making reference to it because it is actually in a permanent form. So you don't have to prove there was actually damage or injury caused for you to be able to bring such an action in a court of law. So immediately you hear that someone has been able to maybe make a particular announcement in a newspaper about which is not factual, then you can be able to sue such a party or such a person for what you are calling defamation under libel. Defamation under libel. Defamation under libel. That is what we mean by defamation as a tort. So just remember they are actually of 2 types, and actually be able to differentiate between the 2 types of defamation. So we can have libel or we can have slander. Libel is in a permanent form, while slander is in a non-permanent form. So we can look at the general defenses of tort. The general defenses of tort. So what we mean by the general defenses of tort, they are basically those defenses we've actually been able to come across that can actually basically be used by the defendant to protect himself in a court of law if you're accused of what you are calling maybe defamation, or what you are calling maybe occupiers, liability, trespass, and all those we've actually been able to come across under the law of tort. So in this case, what should actually come to your mind most obviously is statutory authority. It is actually a form of defense under almost all of them. So you can just have a look at them. So you can have volunteer and fitunjaria, where you voluntarily accepted the risk under any tort. Inevitable accident, something that couldn't have actually been avoided. Act of God can actually be a form of defense. Act of God, I think you can actually be able to remember it under this particular tort we learned about, known as strict liability. Strict liability. Strict liability. So this is the rule in, if you can remember the rule in Ryland, the rule in Ryland versus Fletcher. The rule in Ryland versus Fletcher. We looked at the key essential elements under strict liability. And of course, one of the major form of defense we looked at is actually act of God. So that is actually also a general defense in tort. Self-defense, maybe you committed a particular wrong as a result of self-defense. So maybe that one can actually be applied here under the law of the tort of trespass. Under the tort of trespass with regard to persons. So maybe battery. So you ended up committing battery while you're actually carrying out self-defense. Mistake. So a mistake can happen out of necessity. Out of necessity, someone can trespass on someone's land. So maybe there's a disaster or fire on the neighbor's property. So you can actually be able to trespass and enter into the premises out of necessity to simply be able to protect the house of the neighbor. Statutory authority, so that I think I've explained, whereby basically there's a statute or there's a specific law that are actually basically allowed for a particular tort to be committed or a particular wrong to be committed. So it can actually be used as a form of defense, Those are the general defenses that can actually be pleaded under the law of tort, So what is the capacity, or who are the people who have the capability of being able to sue or be sued? So you have different persons. You can have the government. Is the government able to sue or not? So The Government Proceedings Act makes the government subject to certain liabilities in tort as if it were a private person. So the government is liable, for example, in respect to torts committed by its servants or agents. So any wrong committed by an officer of the government will be held personally responsible. In respect of any breach of those duties which a person owes to his servants or agents at the common law by reason of being their employer, in respect of any breach of duties attaching at a common law to the ownership, occupation, possession, or control of a particular property by the government, So the government can actually be sued for any form of tort or wrong committed against a person. So if the government basically, without following the proper procedures, maybe takes over property or land of a person, so they cannot be accused of what you are calling trespass, and they can actually be penalized heavily in case they are taken to a court of law, So infants and minors, do they have the capacity to sue or be sued under tort? As a general rule, minority is no defense in tort. Infants can sue or be sued in the same way as any other person. However, the age of infant may be relevant in some torts where intentions, malice, or negligence of the wrongdoer are the main cause of the torts. So you can be able to see that under certain torts, it doesn't matter whether you have attained the age of majority or not, an infant or a child can still actually be held responsible. So as you know, we have maybe what you call the juvenile courts. So in this case, those people who have not actually attained the age of majority, that's where they can actually be tried by a judge in a court of law. So any child or basically infant who has been involved in a tort or a particular tort can actually also still be held responsible under the law of torts. So they can't actually escape. But of course, they have said they look at the circumstances and also the age of the infant in terms of trying to determine whether he can actually be held responsible or not. So in this case, what we mean by this, for example, a 2-year-old or a 6-month-old or maybe a 1-year-old child, they don't have the same thinking capacity with maybe a 5-year-old or maybe a 10-year-old or maybe a 12-year-old child. So that one of maybe 12 years is a bit mature, so he or she understands some of the things. So if he does something wrong, he can actually be able to tell. So you can't compare a child of 12 years and maybe a child of maybe 3 years or maybe 4 years or 5 years. So those ones are not actually quite mature enough to be able to understand most of the things. So the court will look at the circumstances as to whether this particular infant can be held responsible or not. But you are saying generally, they don't actually escape or can't actually escape from being held responsible under the law of torts, Husband and wife. So the position of a husband and a wife in tort is covered by 2 English statutes. So this one is actually borrowed from the common law. So the former act is a statute of general applications in Kenya. So a married woman, so this is where it is important, a married woman is liable in tort and may sue or be sued in tort in the same way as though she were a female sole or a single or unmarried woman. A wife can sue her husband in tort for the protection of her own property, The president, so the president is sometimes immune from any wrongdoing until maybe he leaves office. So the Constitution of Kenya provides that the president of Kenya is not liable to any proceedings whatsoever in any court of law. It means that no civil or criminal proceedings can be instituted against the president while he is actually still in the office. So until maybe he leaves the office, that's when he can actually basically be brought before a court of law and actually accused of a civil wrong or a criminal offense. So heads of states and diplomats. So what happens in the case of diplomats? In this case, we are talking about ambassadors or maybe high commissioners who represent other countries. For example, in Kenya. So are they actually immune also to maybe being held responsible or being brought before court proceedings? So the heads of foreign states, diplomats and foreign missions and certain other persons connected to them are immune from the jurisdiction of of the local courts. Their immunity is provided by the Vienna Convention of Diplomatic Relations, which was signed in 1961. So basically what will happen in that regard, for example, an ambassador of the United States in Kenya, he cannot actually be held responsible for any torts committed actually while serving as a diplomat in Kenya. So it simply means that the only country that can actually be able to hold such a person responsible is maybe the international courts, or maybe it is actually basically from the origin country whereby he has actually come from. But of course, they're actually immune from any court proceedings, while they're still serving as maybe ambassadors or maybe high commissioners in the countries they actually serve, as basically outlined in the Vienna Convention of Diplomatic Relations. So accredited diplomats and their staff families enjoy immunity from criminal or from the civil or administrative jurisdiction of their local courts. The immunity does not extend to Kenyans who are employed by diplomatic missions. So, for example, if you work for a diplomatic mission, it doesn't mean that basically you're actually immune from court proceedings. You are simply just an employee there, so you can still actually be held responsible. Then corporations. So corporations, basically we're talking about companies. So these are basically recognized as being persons under the law. So they can still actually be held responsible. So Safaricom can actually be able to sue Airtel for any wrongdoing by Airtel. So Airtel being a corporation, it is not actually basically immune or cannot actually be exempted from what you are calling the law of torts or any wrong that they have actually committed against any other party. Trade unions. So trade unions have capacity to sue in tort, but actions against them in tort are limited. So that particular act or that particular section of the act provides that no action shall be brought against a trade union for torts committed by its members or officials in respect of any act done in contemplation or in furtherance of a trade disputes. For example, if a trade union calls a strike, it cannot be sued by an employer for the tort of inducing a breach of contract. What of persons of unsound mind? So these are actually also protected under the law. So these are generally liable in tort unless intent is necessary element, and their condition is such that they could not have formed such an intent. So there's a case law there about Morris versus Marsden of 1952. So a defendant took a room at a Brighton hotel. While there, he attacked the manager of the hotel, that is the plaintiff. It was established that the defendant was suffering from a disease, from the disease of the mind at the time of the attack, that he knew the nature and the quality of his act, but he did not know that what he was doing was wrong. It was held that the defendant knew the nature and quality of his act, as he was liable in the tort for the assault and battery. It was immaterial that he did not know that what he was doing was actually wrong. So aliens, what about aliens and non-citizens? So aliens are basically enemies in foreign countries or in countries which they are not actually citizens. So an alien is under no disability and can sue or be sued. However, an enemy alien basically they mean a foreigner who is actually, for example, in our country, and as Kenya as a country, we are basically fighting with that particular country, or we are actually at war with that particular country. So any citizen from, for example, DRC or Democratic Republic of Congo, if Kenya is actually at war with DRC, it simply means that all those citizens who are actually in Kenya from Democratic Republic of Congo, they'll be known as enemy aliens. So they are basically foreigners who are actually in a country from an enemy country. So DRC becomes an enemy country because we are fighting with DRC. Or maybe you can come closer home. You know the country you are really at war with or fighting with currently. So that is Somalia. So Somalia, we are fighting over a particular territory, So that territory is over the sea. So in such a case, if you're actually at war, you are not actually in good terms with Somali, it simply means that all those citizens who are coming from this particular country, they'll be known as enemy aliens in Kenya. And of course, all Kenyans who are actually in Somalia, they'll become enemy aliens in Somalia. So that's what we mean by an enemy alien, simply a citizen or a foreigner from a country that is actually an enemy country. Judicial officers. So judicial officers are protected from civil liability for any act done or ordered by them in the discharge of their judicial functions. That's where a judge or a magistrate utters words which tend to reflect on a person's reputation or orders a party property to be attached in satisfaction of a judgment that no action can respectively be brought against him for the trespass. So the judges simply make rulings according to the law. So they are guided by the law, so they can make certain pronouncements. So those pronouncements basically can actually be seen as maybe being a wrong committed against a particular person. But of course, they are following the law before they make the pronouncements. So in such a case, they cannot actually be accused under the law of tort, under the law of tort, under the law of tort, under the law of tort. So those are basically persons, how you can actually do to look at persons as to whether they can be held responsible under the law of tort, or they cannot actually be held responsible under the law of tort, under the law of tort. So that's basically what you need to be able to understand about defamation, and of course, occupier's liability, and of course, the general defenses under the law of torts, and of course, also the persons who can be held responsible under the law of torts. So that's simply the end of this particular topic. So I would like us to start another topic. So after this, so another topic after this. So we are going to start a new topic. So that new topic is known as the law of contract. That new topic is known as the law of contract, the law of contract. Law of contract, the law of contract. So of course, what you need to understand here is what is a contract, and the characteristics, then the types of contracts you can have, types of contracts, you need to be able to understand also the terms of a contract, then what we call vitiating factors, in a contract, Then also there is something about persons or parties persons or parties who can enter into a contract, who can enter into a contract, who can enter into a contract. So vitiating factors. Then lastly, basically is termination of a contract. How does a contract come to an end? How does a contract come to an end? So these are the major areas you need to be able to understand under this particular topic we are calling the law of contract, the law of contract, the law of contract, the law of contract, the law of contract. So when you talk about a contract is simply an agreement that gives obligations to certain parties to be able to fulfill. So an agreement of promises entered into. So there is normally just a promise that basically someone makes that he'd be able to fulfill under that particular agreement or under that particular promise. So when you talk about a contract, is simply an agreement of promises which is legally binding or is actually enforceable by law. It is simply an agreement. It is simply an agreement of promises. So an agreement of promises, which is enforceable, under the law. It is simply just a promise someone gives. So you wait for maybe that particular party to be able to fulfill, or person to fulfill. So it is just a promise I've made that I'll be able to teach this particular unit up to the end. So I should actually be able to ensure that I'm actually able to fulfill this particular promise. Failure to which you as a person or you as a student, you can be able to take certain actions against me as the teacher. So it is usually binding. So we normally say it is an agreement of promises which is binding. It is supposed to be actually which is binding and enforceable under the law. So it's actually binding. It is actually binding between me and you as a person. So on the other hand, you have made that your own promises that you'll actually be able to meet the cost in terms of the expenses that are supposed to be incurred for running this particular course. So you'll pay the tuition fee. So it is a promise you've made. Maybe you'll pay installment wise. So it is a promise you've made. So we are waiting for you to be able to fulfill this particular promise. So when you talk about a contract, it is just simply an agreement of promises that are supposed to be fulfilled by certain parties under that particular agreement. And of course, it is actually enforceable under the law. See, this simply means that if one of the parties actually fails, it can actually be enforced under the law. So you can be able to compel the teacher, since you paid for the whole of the semester's fee, you can compel the teacher. It is actually enforceable under the law. You can simply take certain actions against the teacher for failure to be able to fulfill his promise of having to teach this particular unit up to the end. So what are the key essential elements of a contract? What are the key essential elements of a contract? So when you talk about the key essential elements, we're talking about the key characteristics that must be present for a particular agreement to be seen as actually being a contract. What are the key essential elements that must be present for a particular agreement to be seen or concluded as actually being what you are calling now a contract? So number one, what should actually be present essential element is what we are called, there must be an offer. So that is number one. Number two, there must be an acceptance. There must be what we call acceptance, that I'll be able to give an offer. Then on the other hand, as the student, you'll actually be able to accept. So there must be what we are calling an offer and an acceptance. Then number three, there must be an intention to create a legal relationship. Intention to create a legally binding relationship, a legal relationship. There must be an intention. So there must be seen to be some form of intention to create a legally binding relationship between the parties. So it should be something that is actually binding, and actually certain actions can actually be taken under the law if someone fails to fulfill his promises. Then there should be the capacity of the parties to contract. There should be the capacity of the parties to contract. So number 4, capacity of the parties to contract. Capacity of the parties to contract. Capacity of the parties to contract. Then there should be what we call free consent, not out of coercion or being forced to enter into an agreement. There should be free consent. There should be what we call free consent. Free consent. Then there should be what we call a lawful consideration, or simply can just say consideration should be there. A lawful. There should be a lawful consideration. So these are the key essential elements or characteristics that should be present in an agreement for it to be concluded as actually being a contract. So number 1, you've said there must be what you are calling an offer. So the offer is just there, you've seen it, that classes are being offered at 3,500 live Zoom classes, 3,500 per semester. If you add a particular amount on that particular amount on that, maybe that 500, you'll be able to get a revision kit. For that, maybe if you add another 3,000, you'll be able to get maybe some of the videos or previous videos. So that is an offer that has been given to you. At the other end, you'll simply accept. You'll simply accept. You look at the offer and actually compare with other competitors of RCM. Look at it, weigh, do I go this side? Do I go this side? You look at maybe the quality of the teachers. You decide that this is the best offer, I'm going to go for it. So you accept. So you simply be able to accept. There are several ways you can actually be able to accept, maybe by your conduct, how you conduct yourself. So first of all, maybe you reach out by phone. You'll maybe ask, how do I enroll for the classes? What happens? What are the procedures? So by your conduct, you would have actually basically accepted this particular offer. Then both parties should actually be, there should be a consideration. You're not just coming to RCM for nothing. There's this thing that actually RCM is offering. They're offering tuition via live Zoom classes. That is the consideration that is being offered by this other party we are calling RCM. What about you as a student? Basically, you are there's something you are giving in. You are giving in a consideration known as the fee. You are paying that 3,500. That is the consideration. So in each and every contract, this element will actually be present. There must be something that the other party is actually offering, while also at the other end, there must be something the other party is actually offering. So in this case, in any agreement or in any contract that is being signed by either two parties or maybe two, 3 or more parties, there should be some form of consideration you're actually basically looking at to get from the other end. So if it is a marriage contract, so of course, you know, it is normally a contract between two parties. Till death do us part. So you're going to be husband and wife. Of course, you as the wife or you as the lady, there's something you are looking at the other end. So there's a consideration that is being brought in by the man, while also at the other end, the man is actually also looking at you as the lady as something you're actually also going to offer. So basically, there's a consideration that the wife or the lady is looking at from the husband, while also the husband, when he looks at the other end from the wife, while they are signing that contract, they have just wedded, or that particular agreement, they have just wedded. So they look at the consideration. So look at the consideration. What is the man offering? What is the man offering? What is the lady actually offering from the other end? So in any contract, that is what I want to mean. There should be some form of consideration. The price that the other party is actually paying. That the lady is going to leave the parents. So that is some of the price that is actually going to pay. Leave the parents and actually basically go to stay with the husband. So on the other hand, that the man is actually basically going to pay for There's a consideration that is being paid. So he's going to bring in a lot of cows, or maybe a lot of goats. So that is the price, that is the consideration that is being paid from the other side. So in any contract, there should be that particular key element that should actually be present. It is normally a free consent. So this case, it simply means that you cannot be coerced to maybe live with someone you don't love. It simply means that when the husband and the wife are getting together, that there is what we call free consent. So you cannot be forced. You as the lady, you as the lady, you are the one who knows what basically you are getting out of it. So you freely just accept. It's normally through free consent. You cannot actually be forced by any person, so to get married to another person. So it simply means that any contract is out of what we call free consent. I cannot force you as a student to enroll here for the classes. You have options. You can choose other persons. So it's not a must that I'll hold on to you like this. And you won't have basically liberty to be able to maybe think through your mind or make decisions on your own. So it simply means that before you enter into any contract, it should be out of what we call free consent. So this simply means that, for example, if someone forces you to enter into a contract, then it simply means that that particular contract, at the end of the day, there will be what we call a vitiating factor. If anything arises maybe in future, then that one will be one of the things that can actually be looked at as basically that was not a proper contract that was actually entered into. So this lady was actually basically maybe forced by the aunt or threatened by the aunt because she has no any option of where she can actually be able to stay to maybe undertake a particular role. Or maybe your aunt actually took a loan from maybe a Shylock. So you stay with your aunt. So you are at the mercies of your aunt. So your aunt basically forces you to pay the loan on her behalf. So you are paying the loan, but it's not actually out of what you are calling free consent, out of not what you are calling free consent. So in any contract or agreement, there should be this particular element you are calling free consent. No person or no party should actually be forced to basically enter into a contract or out of maybe being threatened or maybe being forced. So these elements should actually be present for any valid contracts to exist. Then we are talking about capacity, the capacity of the parties to be able to contract. You realize that, for example, under certain contracts that persons who have not attained the age of majority cannot enter into certain contracts. For example, contracts of employment. So they'll simply ask for you, one of the things they ask, do you have your national ID? They want to identify whether you have attained the age of majority so that you can actually be able to be employed. Most of the contracts, you must have attained the age of majority, but we'll see later on that under exceptional circumstances, that a minor or a person who has not attained the age of 18 years can actually be able to enter into a contract. So there are usually maybe two or very important occasions or circumstances. One of the major ones, we normally say, for example, if that minor or that person who has not attained the age of 18 years is acquiring what we call necessaries. So that is an exception whereby a person who has not attained the age of 18 years can be able to enter into a contract. When you talk about necessaries, these are simply things, or basically you can call them basic needs. So you learned about it in business studies. What are the basic needs? You have food, shelter, and clothing. Food, shelter, and clothing. So that was basically what you learned about. The basic needs, or the basic human ones, are food, and of course shelter, and of course clothing. So when the miner is actually trying to attain or achieve these particular three, then it can actually basically be accepted to enter into any contract. So you can simply walk into any supermarket and buy a mandazi and actually be able to take or eat the mandazi. So you can't basically deny that person that he has not attained the age of 18 years, so he is not actually allowed to maybe enter the supermarket and buy such. So under exceptional circumstances, only when persons who have not attained the age of 18 years can actually be able to contract. So it has to be looked at, this person, does he have the capacity to be able to enter into a contract? you might be entering into a contract or an agreement, yet the other party is a person of unsound mind, or maybe is actually insane. His thinking capacity is not actually proper. So you are most probably you are likely to manipulate that person because his thinking capacity is not actually okay, or maybe straightforward. So it has to be looked at. Does this other party or does this person have the capability or the capacity to be able to enter into a contract? Is he a person of unsound mind? Is he a person who has not attained the age of 18 years, or he has attained the age of 18 years? So this one has to be looked at. It should actually be present, an essential element that should actually be present when an agreement or any agreement that can be concluded as being a contract is actually being entered into. So that's what we mean by capacity or capability of actually being able to contract. There should be what we are calling intention to create a legal relationship. So that agreement you are entering into, in short, it should be actually lawful. It should be lawful. It should be something that is not actually, that is actually outlawed or actually illegal. So, for example, if you're entering into an agreement to basically maybe sell drugs which are not actually allowed in the country, or maybe you are being involved in maybe money laundering, so those are outlawed activities. So that cannot actually basically be concluded as being a contract. There must be an offer and an acceptance. So that one I think I've already explained. So those are the key essential elements that should actually be present before an agreement or any form of agreement can be concluded as actually being a contract, can actually be concluded as actually being a contract, can be concluded as being a contract. So we can take a 1-minute break before maybe we continue with the types of contracts that we can actually be able to have, the types of contracts that we can actually be able to have. So we can wind up by looking at the types of contracts. So what are the types of contracts you can have? So you can have a unilateral or bilateral contracts. So you can have a unilateral or bilateral contracts. Unilateral or bilateral contracts. Express and implied contracts. So these are instead of or, you can just say and. Express and implied contracts. Express and implied contracts. Valid. Void and voidable contracts. Valid, void, and voidable contracts. So you can have valid, void, and voidable contracts. Valid, void, and voidable contracts. We can have specialty contracts, and simple contracts. Specialty contracts and simple contracts as another type of contracts. So specialty contracts and simple contracts. You can have contracts 𝗖𝗙𝗙𝗎 fidei, contracts 𝗖𝗙𝗎 fidei or utmost good faith, contracts of utmost good faith. Contracts of utmost good faith. Sometimes we say contract 𝗖𝗙𝗎 fidei. That is actually in Latin, simply means utmost good faith. Contracts 𝗖𝗙𝗎 fidei, contracts 𝗖𝗙𝗎 fidei. Then the last one, the second last one, contracts of record. You can have contracts of record. Then we can have executed and executory contracts, executed and executory contracts. Executed and executory contracts. Executed and executory contracts. Executed and executory contracts. So those are some of the types of contracts you can actually be able to have. So when you talk about a contract of utmost good faith or a contract of 𝗖𝗙𝗎 fidei, it is simply a contract where one of the parties is actually expected to act with what we call utmost good faith or in the best interest of the other party. The best example you can actually be able to give is, for example, a contract of insurance. So always when you are acquiring an insurance policy, there are certain questions that this insurance company will actually be able to ask you as a person. So you'll be able to provide the information. So they are simply just depending on you to act with what you're calling utmost good faith, because some of the information they cannot actually be able to verify. So if they ask for your medical history, maybe you can give true information or not, because sometimes they're not actually able to verify whether what you're saying is actually true or not. So at the end of the day, what is actually expected from you is for you to act with what we call utmost good faith as the insured person. So such kind of a contract can actually be termed as being a contract of utmost good faith, or we call it a contract of 𝗖𝗙𝗎 fidei, like a contract of insurance. You as the insured party, when they ask about the medical history, you are supposed to basically give information which is actually true or basically factual. So this cannot actually maybe be ascertained by the other party, but it is actually expected you will act with what we call utmost good faith. You will act with what we call utmost good faith. So that's what we mean by a contract of utmost good faith, or a contract 𝗖𝗙𝗙𝗎 fidei. That is what we mean by a contract of utmost good faith, or a contract 𝗖𝗙𝗎𝗎 fidei. Then we have unilateral and bilateral contracts. We have unilateral and bilateral contracts. So just from the word bilateral, it simply means two, or basically unilateral simply means one. So that's why they are actually related or correlated. So a unilateral contract is one in which only one party is actually bound. It is usually a very rare form of contract. It is usually a very rare form of contract. It is simply where only one party is actually bound. When we talk about a bilateral party, then two parties are actually bound, or we have both parties, the one maybe making the offer and the acceptance, both of them will actually be held responsible or will become liable. So a bilateral contract is one in which both parties are actually bound. So me as the teacher and you as the student, both of us are actually bound to fulfill a certain obligation. No one is actually exempted from maybe obligations under the contract. But a unilateral contract is where we are saying only one person is actually bound. So the best example we can actually be able to give is, for example, if there's a promise to reward anyone who might recover a particular property, or maybe if they put out a notice by the government that they are looking for a particular criminal, that anyone who basically produces the criminal will actually be given a reward. So no one is actually bound from the public. Any person can actually be able to identify the criminal from nowhere. So they are not actually binding a specific member of the public to be able to bring out this particular criminal they are looking for. So the only party that is actually bound in such a case is actually the government itself, by simply giving out a reward. That reward actually binds them, because if anyone from outside is actually able to bring the person, then they'll actually be able to give out the reward. But of course, they don't know exactly who they are binding the other end, because anyone from the public or any member of the public can be able to give that information about this particular criminal they are looking for. So that's what we call a unilateral contract. Only one of the parties is actually bound. So bilateral contracts are the most common. So in this case, both parties, the offerer and maybe the offeree or the other party, both of them are actually bound. Then you have an express or implied contract, an express or implied contract. So an express contract is one in which the parties specifically agree about the nature and terms of their relationship. So in this case, the terms are actually very express. They come from the parties. So when you talk about an implied contract, it is basically like a formatted or a contract that is actually basically expected to be in a particular format. So you can't be able to change that particular format. So there's a standard way of how that contract is normally carried out. So if it is maybe a sale agreement for land, maybe it is a uniform agreement that must actually be used in basically acquisition of land. So there's nothing you can be able to change about this particular formatting or these particular terms in that such a kind of an agreement. So that's what we mean by an implied contract. Then you have valid, void, and voidable. So a valid contract is one that meets all the essential elements of a contract. So if all the essential elements of a contract are actually present, such kind of a contract can be termed as being a valid contract, Void one that is now the opposite of valid. It doesn't have any of the essential elements, or the essential elements are not actually present in such kind of an agreement. So the contract will be termed as being a void or simply an invalid contract. So if it is valid, the essential elements are actually present. If it is void, it simply means that it doesn't have the essential elements of a contract. So it is a void contract or an illegal contract. Voidable is basically one where one of the parties has an option to be able to avoid such kind of a contract. So if you have the option under the terms, then we can actually be able to term such a contract as avoidable contract. So this simply means that if the students have not paid, then of course the teacher can actually be able to fail to continue to teach. So you can simply avoid, or basically avoid, that particular contract. So it is an avoidable contract. It doesn't actually basically tie the teacher. It depends on whether the students have actually been able to pay for the tuition. So it can be termed as being avoidable contract. Then you have executed or executory. Executed, just from the word executed, it has already been executed. So it is a contract that basically all the terms and obligations have already been fulfilled in the past, like for example, a month ago. So that contract will be termed as having been already executed. Executory, the promises or the agreements or the promises under the agreement are supposed to be fulfilled at a future date, maybe a month from now. The promise is that the teacher will actually be able to provide block revision. So in such a case, that is an executory. So it is a promise that has been made to be fulfilled at a future date. So such kind of an agreement can actually be termed as being an executory contract, Then you have specialty contracts and simple contracts. So when we talk about specialty contracts, these are contracts basically that must have, for example, a common seal, or maybe must be stamped or sealed before they can be recognized as being contracts or basically agreements. So maybe if it is a certificate of incorporation of a company, so of course it must have what we call a common seal from the register of companies. So it can be termed as being a specialty contract. So simple contracts is an agreement, whether express or implied, which gives rise to legal relationship. A simple agreement may be in writing, or maybe sometimes it can just be made orally. But most of the specialty contracts are usually in written form. And of course, there must be what we call a common seal. So they must actually be sealed or maybe stamped. Then you have contracts of record. What do you mean by contracts of record are, for example, the rulings or judgment that are normally made before a court of law. So they are usually kept on record by the judge. So reference can actually always be made to them at maybe a future date. So those judgments or those particular judgments that are normally made might compel a certain party to fulfill certain obligations. So maybe they might give out injunction orders, they might give out eviction orders. So several orders can be given by the court. So the party who has basically been called upon to maybe be evicted from a particular area has no option but basically to follow what the contract has made, the pronunciations the court has actually been able to make. So those kind of contracts or agreements that are basically led to as a result of a court ruling or a judgment will be termed as being contracts of record. So those are the types of contracts that we can actually be able to have, the types of contracts that we can actually be able to have under the law of contract. So I think for today we can be able to go up to that particular point. So unless there's a question, you can maybe pose the question. So I can see we are remaining with the Anne. Do you have a question? I don't know whether Anne has a question. Anne, do you have a question? What about Becky? So Anne says no.
No, I don't.
So I think we'll meet in our next class. So that is, I think, is it on Thursday? It's on Thursday. You can have a good night.